So you drafted your will either by yourself or with help, and you're absolutely confident that the wording makes perfect sense in English, doesn't contradict itself, you haven't included any terms that you are not 100% clear about, and you haven't missed anything. So all being well, you're good to go. Your will is fine, yeah? Not necessarily. A couple of things you need to be aware of where your will might be vulnerable to getting challenged, and here's how to protect your will. Now, this is really, really important, particularly if you are an older person and if you want to use your will to leave your estate in a way that is perhaps not as conventional as normal. You're 100% entitled to do that, but you might be inviting a challenge. The most common scenario I see is an older person who has grown-up children, perhaps in midlife, and that person wants to leave their estate not in a way that leaves it evenly to all of their children in equal shares. That's the most common example, okay? Now, freedom, testamentary freedom is absolutely a thing in the UK, but you have to be able to demonstrate that you have freely exercised your testamentary freedom, because if that is in any way uncertain, it's possible for a disappointed beneficiary to challenge the validity of your will, basically saying that you haven't properly exercised your testamentary freedom. Two key ways that this happens. Number one, lack of testamentary capacity. Now, this is absolutely a key issue if you're older and you're not in the best either physical or cognitive health. You've got to follow what's called the golden rule. You've got to be in a position where you've got contemporaneous evidence that you meet the test of testamentary capacity. What that means is that you have got enough capacity, enough cognitive ability to understand what your estate consists of, what it means legally to make a will, and what the normal kind of conventional approach would be in a situation like yours, who the normal kind of expected claimants upon your estate might be. Because if you want to derogate from that in any way, which is your freedom, you have to show that you've done so freely and you know exactly what you're doing. Now, more often than not, people in that situation, if they are kind of following this recommendation, they'll go and ask their GP. They'll say, look, can I pay you to write me a letter saying that you've either spoken to me or you've looked at my medical records and you're perfectly satisfied that I fit the criteria of a person who knows what they're doing in this situation. What I am seeing in practice, increasingly now starting to creep in, is that a lot of professionals within the NHS, some GP surgeries, some hospital wards are very, very reluctant and often outright as a matter of policy refuse to get involved in this process at all. If that's the case for you, don't lose heart. There are independent medical providers out there who can, if you pay them, carry out an independent assessment of your testamentary capacity. It's not cheap, but it's an awful lot cheaper than ending up with your estate not actually being passed exactly the way you want it because of all of the legal expenses that would be involved in, say, a court case or litigation surrounding a challenge to your will. So seriously explore that if you're in any way concerned that your testamentary capacity may be brought into question. Absolutely get advice from a professional anyway, from a legal professional who will be able to identify whether you are vulnerable to that kind of an accusation being made and can perhaps signpost you and guide you to the appropriate solutions. Second massive one is about undue influence. Now, this is very, very important if you are, for example, wanting to leave the bulk of or all of your estate to one person when there's multiple people who would typically benefit from an estate like yours. So again, the example I often see is somebody might want to favour one of their children, one or more of their children over their other children for entirely valid reasons. You know, it might be that there's been an estrangement, or it might be that that particular child is more in need, or perhaps has given more support and love and attention over the years. Nobody's business but yours, okay? You know, but undue influence is a really, really big issue. Now, what this is all about is that your will can be challenged once again by a disappointed potential beneficiary saying, oh, well, this person who's benefited from this deceased person's estate obviously hoodwinked or coerced the testator, or the person who's made the will, into making their will in this way. Now, none of that is particularly easy to prove. The person making that allegation has got to prove it, and there's a very high standard of proof, but that's not a reason to sit on your laurels, okay? You do need to make sure that you are following sensible basic safeguards. In a situation like this, what I would 100% say is don't make it on your own, because then you're doing it in a vacuum and it's just leaving room for all these suspicions to kind of creep in. So don't do that. Go and get legal advice about it, okay? When you go and get legal advice, go entirely by yourself. Do not have any involvement at all by the person who's going to be the main beneficiary or the main executor, etc. of your estate. You have to be in a position where an independent legal person is actually making a careful note on their file that can be shown later to show that you were there by yourself and that you were freely expressing this wish and that nobody was guiding you or directing you in that wish. So yeah, these are very, very important things. These are steps that you need to take to make sure that your will is absolutely invulnerable, as far as possible anyway, from being challenged, and that your wishes are respected.